Welcome to 5 Dubs by MDDC Press. I'm your host, Rebecca Snyder, the Executive Director of the Maryland, Delaware, and DC Press Association, which represents news media in our region. 5 Dubs focuses on the who, what, when, where, and why of local news media. We'll talk with the journalists about the stories behind the news. You can find more information about our guests in the show notes or on our website, www.5-dubs.com. Welcome to Coben Zweifel Keegan, the Managing Director of the IAPP. So, Coben, welcome to our program. And did I ruin your name? I feel like I might have.
No, you did. You got it right. Yeah, Coben Zweifel Keegan. Yeah, you got it.
All right.
Yeah,
well,
thanks for having me. It's great to be here.
An early win, I guess. So tell us a little bit about what the IAPP is and what your role is.
Yeah. So the IAPP is the International Association of Privacy Professionals. We are a professional association, a global nonprofit focused on the people who do the work of data privacy and data protection to comply with those laws around the world, as well as increasingly AI governance professionals, the people who are working to incorporate best practices for governing AI systems, both privacy and otherwise, as those best practices evolve. But we've been around for about 24 years. As the privacy profession has matured and become its own special cadre of qualified people who make sure that companies and other types of organizations are handling personal data properly.
Right. And so privacy in general has been an important piece of the puzzle for many years, but in recent years, there's just been this groundswell of online privacy protections, kids' data privacy. So, and that's happening, of course, we hear a lot about the UK, we hear a lot about the European standards, what can be done in the US. And so for many of our listeners, it all kind of swirls out there to be like, okay, we all want to, keep as much privacy as one can in the digital world, one assumes. But what's the status? What's going on now? And where are we?
Where are we and where are we headed? Yeah, that's a good question. I think you're right. Exactly. We've seen an expansion of the specific rules that require organizations to implement best practices for protecting people's personal information over the past sort of couple of decades, but particularly in the past 7 or 8 years. Privacy as a practice was more focused on principles like transparency and fairness and control, making sure that people have the ability to exercise their choice around how their personal information is handled for many decades, going back to the 1960s when we first invented databases and started to worry about government systems that process personal information. But the biggest sort of stimulus for specific regulations with teeth that could find companies and push companies towards more specific compliance obligations came when GDPR went into effect, the General Data Protection Regulation in Europe in 2016. And so since then, I think there's been a big expansion in how much organizations invest in data privacy compliance and in making sure that they're keeping up to date with those updates. In the US, privacy rules have always been, for consumer privacy rules have been rooted in consumer protection law, which means that it's very focused on what you put in your privacy policy, making sure that's not deceptive, that you're not saying one thing and doing something else, or that you're not going too far in terms of kind of reasonable privacy practices. The Federal Trade Commission, which enforces that law, the Section 5 of the FTC Act, the kind of general consumer protection enforcer, has been very active in privacy for the past couple of decades, and they keep expanding and helping to make sure to clarify what is reasonable. But since GDPR came in, we've considered in the US federal comprehensive privacy legislation similar potentially to what we see in Europe and many other countries. Now, almost every developed country has some sort of comprehensive privacy framework. Actually, 75% of the world's population now is covered by a privacy law, but the federal US level does not have a law like that. And so instead, the states have been acting.
So in sort of that global privacy laws, you said that about 75% of the world is covered by some type of online privacy or privacy law. Are they similar, or is it or are you seeing big changes between countries?
Yeah, that's a really good question, and it has it's a constant evolution to some extent. A lot of what's out there was influenced strongly by the first major actor in the space, the Europe's GDPR framework.
Mm-hmm.
So that's often called kind of a rights-based approach. It's rooted in the recognition in Europe of fundamental rights to data protection and to privacy for individuals, all types of they're not thinking just about consumers, but about people in every aspect of their lives. A lot of other countries have followed that model in various ways, but we are starting to see some divergence as now it's been 5 or 6 years of GDPR being enforced, and we're kind of learning more about what works and what doesn't work. And also technical systems keep evolving, and now regulators and legislators are thinking about what to do about AI and other more advanced technical systems. So I think we just saw India, for example, pass their comprehensive privacy law last year, and it does deviate from the GDPR a lot. It's not the same kind of framework. It kind of has it's more restrictive in some ways, and it's creative. It's different than what that it's not copying and pasting GDPR. And also in the US, the frameworks that have a couple of years ago, well, last year, we almost saw the passage of the American Data Privacy and Protection Act, ADPPA. And that is quite a lot different from GDPR, just because we have such a different foundation of where our privacy standards come from in the US. But at the end of the day, all of these laws have similar patterns of requirements. They require companies to enter into contracts when they're sharing personal information. They require data protection impact assessments. They require you to respect requests from consumers about their data, opting out of processing of data, deleting information, things like that. So that's kind of the overall contour. Yeah, there's only so much potential deviation. I guess we're seeing more because of a lot of scholarship and thinking from advocates. There's a lot of questions of whether consent-based approaches, kind of opt-in, opt-out laws are the right way to go moving forward, or whether that just leads to a lot of fatigue and kind of puts all of the emphasis on consumers to decide how their information is processed when maybe they don't have all the information necessary. And so we are seeing new laws that maybe deviate from that pattern. Yeah.
Sure. Like, I'm totally befuddled whenever I go into a website and like accept all cookies, just necessary cookies, and like whatever. Just I want to get that information. So it seems like the US is sort of working not in a vacuum, but in a really different space, that it's not, you had mentioned it's not a cookie cutter approach. You can't just pick up, laws from the world stage and then drop them into the US. What are you seeing? Because it is, of course, I want to separate out for our conversation and also for our listeners, online privacy bills from the kids protection bills, because I see them as very different. So if we could first talk about online privacy bills, which, we're here in Maryland, and so Delaware has one, Virginia has one, talk to us about what online privacy bills are looking like in the US, and how they're sort of popping up here and there, and how they're similar and how they're divergent.
Yeah. So as I kind of started to preview, in the absence of federal action to pass what we call a comprehensive consumer privacy law, And by comprehensive, we mean it covers a lot of entities. It's not sectoral. In the U.S., we've historically, we do have privacy laws, but they've been sectoral. They've been focused on specific industries like healthcare or finance or specific people with that are more at risk, like children's privacy. We do have a federal.
So that would be like HIPAA, or it would be those would be kind HIPAA, of the sector based.
FCRA is the financial one. COPPA for children, the Children's Online Privacy Protection Act, and there's a few other kind of specific sectoral rules. And so certain types of entities are covered by those. GLBA is another financial law, but overall, there's not a single standard set of requirements for all types of companies that handle personal data, except for the kind of reasonable privacy standards that the FTC has developed over the years, just by enforcing against kind of what isn't reasonable.
It's not like the total Wild West. We do have.
It's not a total Wild West. Yes, exactly. Okay. And that's really where the profession of privacy emerged, is from kind of looking at those squishy ethical concerns and trying to figure out what is how to earn consumers' trust, and how to make sure that personal data isn't processed sort of in a way that goes beyond what is reasonable for companies to do. But it is certainly more of a Wild West than a more highly regulated structure like in Europe. And because of that, we see it's quite simple. It's much easier to share personal information, for it to kind of spread into multiple contexts and things like that. So because we've been waiting for the federal legislature to act, states decided to take matters into their own hands. And that really got started with California. Sure. There was a ballot initiative because California has a somewhat unique mechanism where voters can put laws on the books based on direct ballot initiative. That's where California's privacy law initiated. They've since updated it again. And other states started to take that model and build on it and kind of evolve it over time. A lot of now we see that kind of everyone is in favor of a federal privacy law. That's shifted from before the state started acting. Now both industry and civil society continues to call for Congress to act and create a single standard.
Do you think that's likely? I mean, it just, Congress has had some troubles recently coming together on anything, but are we just kind of waiting in the wind forever? Or do you think that Congress will act at some point?
At some point, I think it probably will happen. Yes. I think the biggest hurdle right now is just that it's hard to pass anything in Congress. We did come quite close last year, but there are some sticking points where people disagree on the right approach. Things like whether there should be a private right of action for consumers to sue directly under the law, and whether the law would preempt state laws. And that's one of the that was the main sticking point really last time, because California started to be concerned that the new, the proposed federal law was weaker or not the same as their law, and they didn't want to have their law preempted, even in a limited way. Okay. And so other states now might also similarly have kind of a vested interest in maintaining the code that they created, and making sure, or at least making sure that their version of privacy protections are reflected at the federal level.
No, are most states adopting the California model with tweaks? I mean, it's so confusing as a patchwork. I think, if you're trying to implement these policies across multiple states, it can get very complicated very quickly. So are states looking to California as a model, or are they freestyling?
It hasn't been a patchwork. I don't think it's been a patchwork to the likes of which that industry was concerned about. That there still is a very similar set of standards reflected across the now 14 states that have enacted some form of comprehensive privacy law. But yes, there's been a lot of adjustment and innovation around what it looks like in practice. Some of that is because of what some would call industry-friendly codes that are different than California in certain states. In other states, there's been really a concerted effort to kind of modify what happened in California and adapt it and make it more meaningful to their state or to go farther in certain situations. Yeah, it's really hard to say like who has the best or strongest privacy laws because they differ in so many different aspects and including kind of the scope of their application to different types of companies that it makes it hard to compare them one to one. But there are but yeah, you can, if you do kind of, and some of the policy people in the space do, like Keir Lamont at Future Privacy Forum is very good at describing the sort of genealogical threads of different privacy laws. So Connecticut had done a lot of innovation in how it interpreted privacy rules. Colorado empowered their AG to create regulations, and so through those enacting regulations, there's a lot more nuance and a lot more meat to what is required in that state. Yeah, so we do still see innovation, and we've also seen new privacy laws in specific areas like covering health information. Washington State has something called My Health, My Data, which is a very innovative law that will be really interesting to see it go into effect. But yes, exactly. There's also a huge amount of effort on the kids space, which we'll talk about shortly, I guess. But for now,
get to. But before we get there, so these bills are being promulgated and being passed probably in the last couple of years. Are we any more private? Like, are they actually working? Is it too soon to tell? Like, are we safer? Are we more private?
Yeah, is our online privacy protected? Yeah, it takes time for the kind of teeth of these laws to start to be shown and through enforcement actions. Certainly companies, if they're paying attention, are adapting their practices to make sure that they're meeting the requirements here. And that shows up through, more rigorous contracting and requirements for how data is being shared between entities. It shows up in many companies just providing the kinds of data rights that are reflected in these laws across the board, not just saying if you're in California you can request an opt-out, but saying anybody, if you want to opt out of certain types of processing or to delete your data, will honor that request. But at a minimum, it requires the specific states that have laws are requiring those types of practices, like honoring consumers' opt-out requests and things like that. We're also seeing that requirements are we're seeing a slow evolution of a couple of the kind of technical environment around how data flows online, and that's most obvious in the ad tech space, which is often kind of one of the main things in the crosshairs for these types of privacy laws.
Right.
And right now, ad tech is going through advertising technology and all of the kind of marketing use of data online is going through a big change, partially driven by enforcement action in California and in Europe, or at least the warning of things to come, that kind of moves away from moves to a new era of having more privacy protective tracking technologies that might enable and it still enable the delivery of ads based on people's interests, but not so easily spread their personal information around. But that's kind of a long process to get to that point.
It is a huge process, and of course, advertising technology is always evolving and always changing. But what effects have you seen on advertising with either in the UK, which I know is not a perfect example of what would happen in the US, but what are you seeing like in terms of the ability for advertising to be sustained? And full disclosure, the news media industry does a lot of digital advertising, and it's a big part of, it's one of the three pillars of our revenue streams. So it's something we watch very closely.
Yeah, it's such a hard, it's so hard to fully unpack kind of what is how revenue would change based on changes in kind of the structure of these models, right? Because we're stuck with what we have in many ways, and kind of with what the practices are that have become widespread in this space, which may or may not have been a necessity, right? We created the world that we live in, but it could have potentially looked different if we made different choices about how these technologies worked. And so you see some publishers switching to contextual advertising exclusively, right? So like New York Times talked about doing that a few years ago. Contextual meaning you're seeing ads that are more focused, that are either kind of general ads or are more focused on the type of thing that you're looking at the moment, and not focused on tracking you across websites. We're also seeing new mechanisms for the big providers of advertising services like Google to provide insights and advertising solutions that are not that don't necessarily rely on individualized personal information, and instead use more kind of group focused insights, and still deliver some of the same value to advertisers in theory. And I think that's where there's lots of kind of innovation needed, and still need for kind of technical standards. We're also another example, I guess, is on the consumer side, making sure that there's more readily accessible mechanisms to say that you don't want to receive targeted advertising. For a long time, there have been opt-out mechanisms from the industry for kind of browser-based opt-outs for targeted advertising. But now some states like California are requiring what some call universal opt-out mechanisms. And so we're seeing those be slowly built out in both the web and on the mobile environment eventually, where a consumer could say that they don't want to be tracked at one place, and that would carry signal through. Right, that signal would go to the publisher, like in the media context, and then you would, I guess, fall back on other types of advertising solutions instead of targeted.
And so if that's, I'm just always worried because, you know, a lot of these bills are I hear are always like focused on big tech. We want to make sure that, you know, the big guys can't get at our data, and we want to keep everyone safe and things like that. But if you're in this sort of those universal opt-outs, does that create more of a push towards a monopolistic or centralized space? Who's controlling those? Who's controlling the universal opt-outs?
Yeah,
does everyone have to go feed at that trough? I mean, like, are you just picking a winner, I guess is my question.
I think, yeah, competition remains a concern in this space overall, right? And that mostly the universal opt-out mechanisms would be controlled sort of independently of the major ad platforms, but their participation is necessary to make them work. So I think there is certainly a lot of there's certainly power dynamics there. We just saw headlines last week, sort of along a similar vein. Google is investing a lot, along with all of the others, in trying to build out new, like I was saying, these new mechanisms, like a cookie-free future, a different type of new types of tracking technologies that are less privacy invasive. And the UK competition regulator just asked them to pause or slow down their efforts there while they ask them a bunch of questions about competition and their kind of market power in building those solutions and how they might look. So yeah, that it continues to remain a concern. It's always a question, kind of looking at the details of how requirements will be, like if it's something that's easier for big companies to implement versus smaller companies.
Yeah. Well, and certainly for a lot of the digital advertising bills and taxes that we've seen in Maryland, at least, it really felt like the larger companies totally can do that. If I'm Google, if I'm Facebook, yep, I can comply. But if I'm a smaller publisher, it's really difficult. So I want to be mindful of our time, because
I know,
although
too
we could
exciting
talk forever. How does Maryland's online privacy bill stack up? And I'm specifically referring to House Bill 567, Delegate Sarah Love's bill. And she's brought that, this is, I think, the third time it's come up. And it draws really heavily from Connecticut. It draws from others. Can you contextualize that bill for us?
Yeah, it does. It looks very similar. Yeah, exactly like you said. It draws from Connecticut, and so it sort of falls into the set of modern comprehensive consumer privacy laws that we're seeing spread across the states. Last year, we saw the number doubled essentially to 12 from 5, I think 5 or 6. I'm losing track of where we were at different points. It has been a wave, and it was a very busy time for the people who are tracking those state laws. This year we've already seen 2, which is why we get to 14 already. And so Maryland fits the mold pretty closely. The bill it doesn't have a private right of action, which is one of the main, that's true of most of the laws, except for California has a very limited private right of action for consumers to sue under the law. And it has all of the kind of things present that are standard across the state privacy laws that we're seeing. So the right to opt out, the right to limit disclosure of personal information, kind of notices and risk assessment requirements. There's even, I'm trying to check our analysis on this bill. Well, there's limitations on how you process personal information, like specific types of data.
The data collection limitations, I wanted to go a little bit deeper there because Delegate Love is kind of pushing the envelope of what's going on in other states by collection of personal data for a specific product or service requested by the consumer. And so when we look at what I'm kind of puzzling through, and this is more of an advertising-based or marketing-based question, it feels like that will preclude the ability to sort of advertise other services. Like if I buy, one service product like Quicken, QuickBooks or whatnot, and then they come out with a new service, are they able to reach me under that, under a more onerous collection limitation that says you can only collect for that specific service? Like it would say, okay, you can collect because I'm a QuickBooks customer and you can talk to me about QuickBooks, but your ancillary services, a secondary product, maybe you can't. Could you unpack that?
Yeah, sure. Yeah, and I should look at that language more specifically, but usually, we are seeing more states think about these kind of more strict purpose limitations, saying that whether collection or sharing limitations based on kind of creating what we call data minimization, trying to minimize the amount of data that's collected and make sure that it's subject to specific requirements once it is collected. And that's one way of framing it by saying that, that you can only collect data for stated purposes. In some ways, that's how it's always been, in that there is a general requirement or a general best practice to disclose the purposes to which you're putting information. But companies historically have kind of used very vague and broad disclosures about, like, we'll use it for marketing purposes, for example. Right. I think there's likely it kind of depends on the details of, and both in terms of how the language is framed in the requirement, whether it is a strict purpose limitation and that's the only mechanism that you can use to collect information. Like, for example, under the EU law, you can ask for people's consent, or it's equally valid to collect information that is for which you have what they call a legitimate interest, where the company, because of the type of service you're delivering, you have an interest in doing that. And there's a big fight and debate, I guess, in Europe about whether advertising purposes, especially cross-contextual kind of behavioral advertising, is able to ever fall into other mechanisms other than consent. So it's likely that you might need more disclosures. So some of the actual actual impact of something like that might be. You just need to tell consumers more that, like, this is, I'm going to use your information for X, Y, and Z marketing purposes in the future, maybe to include all of my products and services or whatnot. But the idea of data minimization is that it's not necessarily something you can that would just allow you to ask for more consents and get around it. So it really depends on how the bill ends up providing exceptions and things like that.
Sure. Well, and so I'd like to turn our attention to the kids' data bills that are kind of sweeping the nation, the latest craze, which do seem very California based. And Five Rights is an organization that's been really active across the country with this. And when you talk about sort of the sometimes the vagueness of some of these provisions lead to not sort of knowing where sort of, does it just mean more disclosures? Does it mean that it's a different type of disclosure or whatnot? It does create all this uncertainty I think in the marketplace about, well, is this really keeping me more private or more safe? And so what are you seeing there's no kids data bill that has been enacted and is being enforced at this point. Am I correct? Because
that's correct. Yeah, except for the Children's Online Privacy Protection Act, the federal law from the 90s. But for this new wave of kids' privacy and safety laws, they're kind of safety and privacy put together. No, nothing is being enforced. The quick history on those types of laws, they really originated in the UK. The regulator in the UK passed a thing that they called the Age Appropriate Design Code. And it's called that because it is meant to require companies to think about the specific needs of different age groups of children, of youth, from kids and teens. And that's kind of building on the UK general data protection rules that they have. California took that as a model and adopted its own age-appropriate design code. And that was swiftly challenged by industry for violating the First Amendment because of restrictions that it places on companies related to content delivery to children. It includes rules about age-appropriate content and kind of encourages companies to make sure that that they're not harming children in various ways. And some of the requirements, and depending on who you ask, potentially a large number of the requirements have elements that could violate First Amendment speech protections in the U.S. A court enjoined the law from going into effect, and so we're awaiting further litigation on that front to decide what the future of that specific law is. In the meantime, Five Rights and other child advocacy groups are continuing to push for the spread of that type of law, and they have updated it in theory to avoid some of the First Amendment pitfalls. And that code is spreading to a number of states this year. And Maryland is one of those. I think New Mexico, Minnesota, and Vermont have all introduced similar legislation.
So if this
California is also thinking about different ways of changing its law to update it as the court fight continues.
Right. So as it's going on. So the EU bill has been in place for some, or the UK bill has been in place for some time. Is it working? I mean, when you think about the sort of the effort and some of the assessment tools and what goes into the requirements on industry, are children safer because of that bill?
Yeah, I think if you ask companies that question, they would say yes, that it is working, that it certainly was part of the impetus for them to modernize the structures that they provide to children. If you ask advocates, I think they would probably say no, that there's still a long way to go. Part of the issue in the UK is that was a regulation, an implementing regulation It's not quite as strong as having a dedicated legal framework. It is enforceable, but the UK regulator was limited in how many kind of new obligations they could place on companies, although they do require these assessments and a lot of documentation. There has been a lot of change, kind of regardless of the source. There has been a lot of change on social media platforms over the past few years, changing requirements of how children can interact with adults, with strangers, limiting targeted advertising, and getting rid of it for kids and teens on most social platforms just on their own accord. Other kinds of safety mechanisms that help to think about mental health issues, addiction, content-based things like filter bubbles that would show people what they think they want to see, but maybe is harmful content to them. Things like that. So those kinds of adjustments have already been made, whether they are required or not, partially because companies are seeing that regulators are very interested in this, and that parents have concerns about children's mental health and safety online. But obviously it's not going away, and that there are many people think that there's a lot still to be done to make sure that platforms are required to implement these types of best practices. And so I think legislators are going to continue to think about what the right framework is to create affirmative obligations on companies to think about the best interests of the child, which is kind of that's the framing that these age-appropriate design code style bills are focused on.
Well, and so in picking up the UK bill and dropping it into the US, we are different entities, of course. Like how does that get interpreted here? It feels a little bit like, in terms of to me, it sometimes seems like with a lot of these bills, you have to collect so much information to say, okay, I'm a protected person. How does that kind of jive with the online privacy, or how do you stay private while saying, yep, we're going to keep kids safe? And sort of the sponginess to me of some of these bills in identifying, like a significant number of children visit the site, or, reasonably assume, just seems to me to, as an advocate for news media, I look at that and think, well, how should I direct my members to comply with something that's so spongy? So what are you seeing? How would you navigate those shoals?
Yeah, that's a good question. And it's made even more complicated because the age-appropriate design code bills are not the only types of state laws that are being considered and passed right now. There's also more direct bans of teenagers using social media and other types of online systems without parental consent. There's kind of a number of types of codes that are actually pushing towards more requirement for data collection, like you said, especially in the context of estimating or affirmatively figuring out users' ages towards various ends. At the same time, the age-appropriate design codes, the first version of them was more focused on, it did include sort of a more direct requirements to make sure to think more about the types of, to figure out the ages of people on your platform or on your service. The new version does attempt to create language that says that makes it clear that it's not trying to invade people's privacy by creating an obligation to know more about the ages of people on your platform. So, for example, Maryland's bill talks about it actually prohibits providers from estimating the age of children on the platform, but like processing new data just to estimate the age of children on the platform. But at the same time, it is requiring more, if you do know people's age, and also kind of it includes a multi-factor test for figuring out whether a child might be using the service. So it is, yeah. It's a tricky and complicated code to navigate. I think we're still seeing legislators grapple with how to properly scope those types of requirements, because there are interests, like children do have an interest in privacy. Teenagers possibly have a stronger interest in privacy, especially vis-a-vis their parents. And these bills, including Maryland's bill, treats all children under 18 as the same. It's not the same kind of age buckets that you see in the UK approach. Right. But this new version is much more focused on completing these data protection impact assessments and then prohibiting certain types of collection of personal information and uses of personal information. It's kind of broad prohibitions, like sensitive data from children and things like that. So the idea, I think, with that is that it would withstand First Amendment scrutiny, but I think there's a lot of disagreement of whether that's true, especially if we see courts like what we saw in California that take a pretty broad understanding of the First Amendment, and that's consistent with some Supreme Court precedent that kind of sees all sorts of online activity, including not even in the media context, but just the delivery of services online as speech. You'll see that the New York Times filed an amicus brief in the Age Appropriate Design Code case in California on the side of industry, on the side against the code, saying that it did violate the First Amendment. It'll be interesting to see if these tweaks are enough to withstand those same challenges, because they're almost certain to be brought again. But it looks like some states will probably pass these laws this year.
Right. No, and it's still up in the air as to whether Maryland will as well. I think certainly looking at this bill in the posture that it was in, that it started out in last year, this is the second year for this bill, a lot of the sort of content pieces have been amended out, which honestly, from a news media perspective, when the bill was first introduced last year, it really felt like we would have to age gate, or we would have to limit content, which is, antithetical to news media. And so I wanted to talk a little bit about that division between, so many of these bills are focused on that big tech, and news media often gets caught in the crosshairs on this. And so we always ask for a news media exemption for bills like this, because we're not focused on children. We're not the Nickelodeons of the world. We're not Snapchat. Like our audience is very different. And I think, it's sort of, we're spun both ways. We hear some say, oh, news media, it's a dinosaur industry. Nobody pays attention to it. Meanwhile, we're in the crosshairs of bills like this, where we have to leap over tall buildings and do backflips at the same time to say, oh no, we're not targeting children. So how would are media exemptions an appropriate way to go with some of these online bills, especially the child safety bills?
Yeah, that's a tough question. And I don't know. Yeah, I don't think I certainly don't have a position on that question, but I don't, but I think exemptions, the only exemptions we end up usually seeing in these types of bills are things for covered entities under other laws. So you'll see broad carve-outs for entities that are already subject to existing privacy protections, like in the healthcare or financial space. I think you're also even seeing some updates to how that thinking. So we have the Children's Online Privacy Protection Act, right? And that creates kind of a multi-tier structure where either you're directed to children or you're a general audience platform like news media. But there's sort of an in-between area too, where maybe you might have certain products or services that are focused on children. You kind of have to think about that a little differently using this multi-factor test that the FTC has used over time. It's interesting to see the code here. We're talking, the standard in this bill is reasonably likely to be accessed by children. And Yeah, it provides a
That's a lot of
multi-part
words to me.
test.
Like, I don't quite get that and how I would implement that.
Yeah, and it's hard, right? Especially when children include teenagers who clearly are hopefully interested in reading news
Right.
media. I know I was, and I hope that the new people. I hope that. I think the other problem with a broad prohibition or potential problem that people would raise is that. Or a broad exemption, sorry, for media is that media is changing, right? It's harder. It's harder and harder to define what counts as media. But what this does is it says if children would already fall within COPPA, then or if the entity would already fall within COPPA, then it is reasonably likely to be accessed by children. If it is if the audience composition includes a significant number of children, that would make it count. If it's similar to other services that include a significant number of children, then that would count. If it has advertisements that are focused to children, that would count. And that kind of tracks with how the FTC has thought about this in the past, that part anyway. And then it imposes an idea of doing internal research. It is to figure out what your actual audience composition is. But then the final prong is knows or should have known that a user is a child. That does sound a little broad to me. It strikes me as a fairly broad prong, because it seems to be saying that a user, if any user is a child and you know it, then you're reasonably likely to be accessed by children.
Right.
And so, yeah, I think that could include a lot of companies, a lot of organizations and web online services. But I mean, keeping in mind that this doesn't, what this requires is that for those children, there's not targeted advertising delivered, among other types of requirements, including conducting these assessments to make sure, like part of this is this papering exercise to say, have you considered all of the factors that would make sure that you're in the best interest of children? And in many ways, conducting those assessments is already a best practice. Like privacy impact assessments are already a best practice. So this just asks these additional questions to make sure that you've thought through whether there are potential harms of children on your platform. So in some ways, it's not as onerous of a requirement, but in the situation where it might be placing you in a position to deliver a different version of your service to children or something like that, that can be tricky to navigate.
Sure. So I guess nothing happens in a vacuum. And all these bills are interplaying with laws already in the books and federal laws and state laws and things like that. What do you think is next for the online privacy movement? Do you feel like in some ways, especially on kids' data, it feels like no one really knows, like, yes, in the UK, industry says they're safer. Advocates say they're not, say kids are not. We haven't had any bill actually go into effect in the US, so we don't quite know. And online data, online privacy bills seem to, they're taking the world by storm now, 14 on the books, all kind of similar. Where does privacy go next? Privacy and safety go next?
Yeah. It will continue to evolve. The fun thing about being in this field is that it is swiftly moving, and we're always learning new things and adapting best practices. And part of that's because of new technologies and shifts. I think right now AI has become a huge part of the policy conversation, but also the operational focus within organizations trying to figure out how to adapt privacy programs to meet meet the unique kind of harms and challenges that AI systems might pose to users. I should quickly mention on the federal level with the kids focus, the Senate has long been particularly focused on kids protections rather than comprehensive privacy, or at least first before comprehensive privacy protections. And that's still true this year. There is a bill called the Kids Online Safety Act, KOSA, which if anything were to pass this year, it would be that it's different. It's not an age appropriate design code, but it's a very similar idea, very focused on protecting kids' safety and providing parents and teenagers with some rights around how their information is processed, how kids' information is processed. and kind of some overall arching obligations on safety. There's also an update to COPPA that would expand it to cover teens. We call it COPPA 2.0, but it's CTOPPA, CTOPPA, the Kids, Children, and Teens Online Privacy Protection Act. That could be kind of something that has legs with COSA or not. That's an open question. But the House has finally indicated that maybe they're interested in also passing COSA. So it really is the one thing where we could see movement, but maybe not. It's still not clear whether there would be time to have any kind of movement on a data privacy law at the federal level. More broadly, we're continuing to think through best practices just for all users. I think the focus from many advocates is to say we should have standards that apply to all consumers before we start worrying too much about these specific demographics, because everyone, in many instances, what the concerns that you have around privacy are not unique to children or teens. There's things that are shared by everyone.
You've got vulnerable older adults who are totally getting scammed like right and left online.
When I talk to organizations, I'm always saying, we should be thinking about all sorts of marginalized communities and people that have additional burdens, not just kids and teens, but what about older adults? What about other individuals? How are they using your platform or your service? How are they thinking about things? Or how can you think about the specific harms that might fall to them to privacy and make things more clear and able to be understood? I think one of the big theme right now really is AI. You can't avoid that in the policy discourse in DC. And states are also thinking about new laws that would apply either to specific sectors. I think Maryland actually has a bill on employee automated decision making.
Right, exactly. So the AI bills are starting to come out on that. So
and so those a big question right now for us is kind of who will do the work of building out those AI best practices, and a lot of that will be the privacy profession kind of modernizing and becoming something new or something bigger to accommodate these new ideas around or new challenges around bias and discrimination and things like that.
Right.
But at the same time, in many ways, the law is still somewhat catching up to what the best practices have been in privacy to make sure that people's personal data is not just shared willy-nilly and is more in keeping with kind of their expectations and things like that.
Sure.
So we'll just keep seeing.
For all those states that are facing kids' data bills, if COSA passes, does that preempt what? Do you think that sort of solves the problem? I mean, it has a news media exemption, so I'm all rah-rah on that.
So
but
you're fine on COSA. That's a good question. I don't remember if it has a specific preemptive provision in COSA. I think because it's less focused on impact assessments, I think it's a little bit different than the age appropriate design. They could, I think, exist side by side. But that might be a factor that the federal legislators are considering, just as they do with comprehensive privacy, is kind of avoiding the potential patchwork that's emerging around kids' safety rules.
Okay, so we have a little bit of a patchwork. We've got competing federal and state world. We've got the specter of AI to change it all. It sounds like it's going to continue to be spicy in the privacy world. So thank you so much for coming to talk to us about this and untangle some of the confusing aspects of it. And I've found it really helpful. So thank you. Thank you for joining us.
Of course, Rebecca. Yeah, thank you so much for having me. It's been great chatting with you.
Likewise. Welcome to 5 Dubs by MDDC Press. I'm your host, Rebecca Snyder, the Executive Director of the Maryland, Delaware, and DC Press Association, which represents news media in our region. 5 Dubs focuses on the who, what, when, where, and why of local news media. We'll talk with the journalists about the stories behind the news. You can find more information about our guests in the show notes or on our website, www.5-dubs.com.